1979, and thereafter with United India, where he worked all over India. And in 2000, at the senior level, he shifted base and he came to the private sector side. And he continued there. He was there with Tata AIG and working at different levels. He retired from Tata AIG as MD and CEO in 2015. And while in Tata AIG, he pioneered this concept of claims negotiations. And he has been associated with our institution for a long time. And I'm very thankful to him to have agreed to join this webinar as a speaker. He has been handling insurance arbitration both at national and international level while in United and while in Tata AIG. We have with us our speaker and the moderator of the program, Mr. Vijay Srinivas. I'll request him to kindly come control screen. Mr. Vijay Srinivas.
Good morning, Vijay Srinivas here.
Thank you. Mr. Vijay Srinivas, he retired from United India after holding joint additional charge of United India as chairman cum managing director. At present, he is a freelance writer, trainer, consultant, and also director of MD India Networks and MD India TPA. I'm sorry, in between, if I pause, it is because I have to admit people. So please excuse me if I pause in between. He joined United India in the year 1981 as a directorate officer, and he has got 4 decades of experience in this field of insurance. For a period of 3 years on promotion, he was transferred as general manager to National Insurance Company. And once he returned from there in United, he became a director, and thereafter he also held the additional joint charge of CMD. He has written many articles in journals and periodicals of repute on subjects like finance, taxation, general matters, insurance, as well as co-authored a book on sales tax. And he's a poet also, not just only a poet at heart, but he actually writes good English poetry. He is my batchmate, so I have the liberty of saying a few additional things. I mean, his poetry I generally like, but anyway, this is not the occasion for that. And I'll now request Mr. Amandeep Singh to kindly come onto the stage. Mr. Amandeep Singh, if you can come central stage. Mr. Amandeep Singh. Mr. Amandeep Singh.
Yes, sir.
Yeah, Mr. Amandeep Singh. Good morning to you.
Good morning, sir.
Mr. Amandeep Singh, presently he is practicing as advocate in Punjab and Haryana High Court. And he's on the panel of POC Insurance Companies. He's a faculty and HR consultant of National Insurance. And he retired from National Insurance as a chief regional manager. He's an LLB, an MA, and a fellow of Insurance Institute of India. And he has a specialization in the field of insurance litigation, or I would say the legal aspects of insurance. So he has a specialization in the legal aspects of insurance. And frankly speaking, as an insurer, I can say that in the insurance industry, this legal aspect of insurance is generally missed. Thank you very much, Mr. Amandeep Singh, for having accepted our invitation and joining us as our speaker. And I'll now like to introduce the youngest member of the panel, Mr. Dr. G. Mallikarjun.
Good morning, everybody. Good morning, sir.
I'll request Dr. Mallikarjun to kindly come center stage.
Good morning, everybody. Good morning.
Yeah, thank you. Dr. G. Malika Arjun, my request is, I'll request again to all the participants, other than the speakers, to kindly switch off your mics and switch off your cameras also. Today is a Sunday. I can understand all of you are in a relaxed mood. But being a webinar, I request that if you have to come on your camera, you have to be in a decent attire. So either you switch off your camera, but everyone should switch off your mics kindly. Other than this,
Sir, you have an option of mute all the people at a time, sir. You can do that, sir.
I'll do that, sir. I'll do that. But I'm doing two work at the both time. I mean, same time. I'm speaking also, and I'm also trying to admit people. So that will do subsequently. Right now, that's why I'm requesting again and again. I'll do that. But right now, I'll request all of you. So I was introducing Dr. Malika Arjun, and again, kindly, come center stage.
Good morning,
Malika
sir.
Arjun.
Good morning to all of you.
Yeah. Dr. Mallikarjun, he took voluntary retirement as general manager of RBI. He never gave us the reason for that, but then he's pretty young, and he took voluntary retirement as general manager of RBI. And in between, he was on deputation with IRDA for 3 years as an officer in special duty. He is a PhD in law from National Law College School, Bangalore, in financial law. And he is a certified associate of Insurance Institute of India. At present, he is, not exactly practicing law, he's more of a freelance kind of person. But he has, he's a certified associate of Indian Institute of Bankers. Then he's a fellow of both life insurance and general insurance from Insurance Institute of India. And he holds a specialized diploma in health insurance. And he's into academics, teaching, banking law, insurance law, corporate law. And he also plans, or rather, I think that he's also started doing actuarial science course. So I'm very happy that he is there with us today in the panel. I welcome Dr. Malika Arjun. So with this, I again welcome all the participants, all the guests, all the speakers to this first professional webinar which ASEAN Institute of Insurance and Risk Management is organizing for professionals mostly. If incidentally any students are there, it's fine. This webinar is being moderated by Mr. Vijay Srinivas. So I request Mr. Vijay Srinivas to kindly take over. Thank you. Thank you very much. But before I request Mr. Vijay Srinivas, I feel that I have not introduced myself. Most of the people know me, but for those who don't know me, my name is Masood Wahab, and I also joined the insurance industry as a director officer in the year 1981. And initially, I was recruited by GIC, but we were given Oriental Insurance. So I started my career with Oriental Insurance and worked at different levels. And I retired in the year 1918 as a regional manager. But I have been associated with ASEAN Institute since 2000. And I have been into training and education since 1992. And at present, I am the director for MBA Insurance course at Jamia Hamdard. This is my brief introduction. I now request Mr. Vijay to kindly take it. Thank you.
Thank you, Wahab. A very good morning to all my fellow panelists and the participants. And I welcome all the participants to this webinar on arbitration and insurance. Why arbitration and what is its role in insurance? That is what we'll be discussing today. A frequently used expression whenever there is a dispute which is unresolved is I will see you in court. I'll see you in court. So it's with varying levels of anger or, in
I'm not
intonation.
getting, I mean, generally, anyone who wants to get in, I get a message, I admit. Either,
This is
either,
very used expression.
yeah, I'm waiting. I mean, ask them to kindly again do it. So as soon as they come, I will admit them.
Wahab, put up your mic. Wahab, put your mic.
Yeah. Am I audible?
Yes, sir. Yes,
Yeah,
sir.
thank you. Yeah. So this is a very common thing that people take litigation to court, and they look upon the courts as the final means of giving them justice or resolving the disputes which they have. The result of that is courts are groaning under the load of cases, and the judiciary is strained. They are doing a wonderful job, but then they are constrained by various things. And the simple statistic, which I would like to share with you, will explain perhaps in a big way as to why the judiciary is flooded with cases and cases are pending. A country like India, with a population of about 130 crores or 140, anywhere between 130 and 140, it has 180 judges for every crore of population. Look at UK. UK, with a population of 6.5 crores, has something like 560 judges per crore. US, with a population of 32 crores, has 1,020 judges per crore. India has 180 judges per crore, US 1,020 per crore. Is it any wonder that courts are burdened and there is pendency in courts? Added to the fact that we do have a big population which is litigious, it's no surprise that courts are burdened. So the need for alternate methods to resolve this. And arbitration is perhaps one of the most prominent and much used. It's something which should be used in a big way. And it has come into prominence of late, with a lot of changes in the law also taking place to make it more easily accessible. It's not something which is new. Arbitration, the reference to that, perhaps the earliest reference to that, is in Brihadaranyaka Upanishad, which dates back to maybe 5,000 or 10,000 years back. It has listed out elaborate arbitral bodies, and they have assigned names and duties and roles to each one of these. Puga is the name given to local courts. Sreni is the arbiters who are in the same profession, business, and would know the intricacies of each aspect of that particular profession or business. Kula are persons engaged in the same, persons of the same community and social group. Put together, all these three cumulatively are known as panchayats. And even the Privy Council in very early stages realized the importance of panchayats and recognized the finality of awards given by panchayats. Not only in India, but world over, this has been the case. Arbitration has been used in various forms. Some of the earliest references to arbitration, which is used in literature, is a biblical reference to King Solomon's wisdom in arbitrating custody of a child where two women were demanding custody. In Arabic, arbitration is known as tahkim, the arbitrator known as hakam. Persian, the arbitrator is known as salis, and the parties to it are known as salises. Greek mythology also has references to arbitration where the gods, there were disputes between the gods, and Zeus, the king of gods, appointed an arbitrator to resolve the disputes. So these are various things, references, and it's ancient. Arbitration is not something new. Even Arthashastra, Chanakya's famous treatise, talks about the various stages in resolving of disputes. All of us would be familiar with the expressions Samadana Beda Danda. The first is Sama, that is discussion. After that, progressively, it changes. So that is how it is. Arbitration is nothing new, and it has been found to be an effective means of handling disputes. In Indian modern law, it started with the Bengal Regulation Act in 1772, as early as that, when the British came. In 1999, Indian Arbitration Act was framed, and in 1940, it was again redeveloped. For a long period, 56 years after that, there was not much changes. And in 1996, coinciding with the general changes in the society, in the commercial world, with liberalization and internationalization, the Arbitration and Conciliation Act of 1996 came into being. This has been subsequently quickly amended to take care of various other aspects which came up and which needed to be addressed in 2005, in 2015, and the latest one in 2019. All this has been done to achieve the object of making arbitration useful and something which is accepted by people and used as an alternate method for resolving disputes. Some of the advantages: it's quick, procedures are simpler than in court, it's cost effective, much lower than fighting it out in the courts. The use of specialized knowledge is used. The greatest thing is the arbiters, or rather the judges, are appointed by and with the consent of the disputing parties. Finality of awards has finally come in through the legislation in a big way. The role of the judiciary has been limited through these amendments which have come in. And one major thing is it promotes confidentiality. It's something which can be kept between the parties and it need not go outside. Why insurance? Insurance is one field where there is a lot of commercial activity, and it deals with large numbers. And large numbers with many disputes coming up because of variable situations, because of lack of awareness of policy terms, conditions, because of lack of awareness of insurance as a subject. Many disputes come up at the time of a claim. And arbitration is an effective method. There are other forms of redressal also for smaller cases, but then arbitration is a very effective method which should be made use of in a big way. Earlier on, the remedies in case of a dispute was one could just accept whatever was given by the insurer, or the second, the most common thing, go to court. Or nowadays, a whole lot of grievance redressal systems have come. They could be made use of. Arbitration provides a wonderful opportunity for resolving grievances and disputes in the insurance field. And today, I'm sure we will be discussing a lot, and we have a panel of distinguished speakers who are knowledgeable in the theoretical as well as have had experience in dealing with arbitration and insurance arbitration. I would now request Mr. Asadullah Pasha, an advocate of long-standing and an arbitrator himself, to share his experience in the field of arbitration and what are the things that need to be done to attract people to this field and see that more people make use of it. Over to you, Mr. Pasha.
Good morning. Good morning, gentlemen. Hello. Am I audible? Hello?
Yes, sir. Yes, sir. You are audible.
I'm not on the screen. Hello.
Yes, I will.
Yeah. Can you see me on the screen?
Yes, sir.
Yes, sir. Yes, sir.
Your camera
Yes,
should
sir.
be...
My camera is on.
Yes, sir. We can hear you. We can see you.
Okay. Good morning to all of you all. I am Asadullah Pasha, Chairman of SADRE, which is Society for Alternate Dispute Resolution and Education. We organize talks, seminars, and short certification courses in arbitration and are trying to spread the awareness that mediation and arbitration can be applied to all disputes in our day-to-day lives and business activities. It gives us a quick and fast resolution to the disputes, as well as drastically reduces the time frame and legal financial costs involved in the normal litigation process. We are all aware that there is a branch of law known as arbitration, but the awareness of this is limited to arbitration as a subject in law. We are far from understanding that arbitration is a quick and easy and alternative method as a form of dispute resolution. It provides us with a platform of a fast and early disposal of our legal disputes. It has taken root in the advanced countries as a prime and first choice of the legal profession to tackle the legal disputes that arise without overburdening the judicial system, as is happening in India. We in India are lagging far behind the international legal community in implementation and use of the medium of arbitration for alternate dispute resolution. Our jurists and legal pundits have time and again been reminding us that unless we build up a strong mediation and arbitration arm of law, our judicial system prevailing today will collapse under the weight of cases that are being filed. It is taking us between 5 to 15 years to get judgments to resolve our cases before the courts. Justice delayed is justice denied is the old saying, which is proving to be true since so many matters are turning infructuous due to the lapse of time, leading to miscarriage of justice. I have been practicing as a lawyer for the last 48 years and have come across a number of advocates and litigants who are still shy and avoid arbitration and mediation. I have tried to find the reason for this shyness and hesitation and have come to the conclusion that it is due to lack of understanding of the law of arbitration and its simplicity in applying it. We only see a few senior advocates and defense personnel who are there as arbitrators who are taking part in the process. The younger generation of the legal fraternity should be exposed to mediation and arbitration as a source of resolving our disputes and on a day-to-day basis should be educated in that. I find that our old panchayat system that was prevailing in our country has slowly lost its charm and its importance in our panchayats. Otherwise, there was a lot of minor disputes that used to get resolved. Now everybody has lost confidence and wants to go to courts. I wish we had more importance given to mediation and arbitration so that slowly the court's burden can be lightened. Recently, I was sitting in the Chief Justice's court in the Telangana High Court, and a matter came up for appointment of arbitrator. After hearing the petitioner, the Chief Justice came to the conclusion that the matter could easily be resolved through mediation. But he mentioned then that the Telangana Bar does not have a strong mediation arbitration center with specialized training and experience like Delhi and Chandigarh High Courts. Of course, our I-Cadre has been playing a major role with Mr. J.L.N. Murthy there at the helm. He is not only trying to spread the awareness of arbitration, but also we have been trying to get involved in training the judiciary, lower judiciary in arbitration, which is doing a wonderful job, I-Cadre is. This needs to be spread further, and a lot of more institutes should be set up to disburse the knowledge of arbitration in our country. I would strongly recommend our viewers to look at mediation and arbitration as a first option when faced with any legal disputes, and train themselves not to jump to conclusions and file cases without exploring the possibilities of mediation and arbitration. Even our lower judiciary, when they are faced with all these cases, firstly, they should try to resolve the small disputes set up by the lawyers by filing petitions and send it to arbitration and mediation, so that only the main problems that are there in legal matters can be sorted out by the judiciary. This is very important for us, as I have seen in the Western courts that Western countries, whenever a case is filed before the judiciary, they ask the lawyers, opposing lawyers, to first sort out the minor issues by mediating and counseling, and then only let the matter come to court. This, I think, is a very important issue, and this should be introduced in our country also. A lot of changes are being brought in the Arbitration Act in the last 15 years, but still a lot needs to become. And today, our subject of this webinar is insurance disputes in arbitration as a first choice platform for resolving general insurance disputes, especially in the field of health and motor claims. The experts in the field will enlighten you as we go along. We have seen that there are very few jurists aware of insurance law, which is a sunrise industry in India, and in the next 5 to 10 years, it will be a major contributor to our economies and disputes in the legal forums. Thank you very much.
Thank you, Mr. Pasha. You have shared with us your experiences and also the feeling of the Chief Justice of Telangana, who felt that we do not have sufficient number of arbitrators, and also your experience that people prefer going to courts. As you rightly said, insurance is a sunrise industry, and there would be a lot of activity in this field, and arbitration will be required to be developed in a big way as far as this field is concerned. For this, our next speaker, Mr. Malik Arjun, would be talking about how insurance contract is different from other contracts, and what are the various types of insurance products, and whether the principles apply to all the different types of insurances, whether it is life or general or health policies. This will give an idea why insurance requires specialized arbitrators. Over to you, Mr. Mallikarjun.
Thank you, sir. The trigger for arbitration is having a contractual clause. And from that point of view, we need to understand two aspects here. One is in relation to the contract. Second is in relation to the business of insurance. So first, why do you need insurance? You need insurance because you are having limited resources to finance the loss that is likely to be caused to you because of various problems that you could face, either in your personal life or in your business or for your family members or in your health, etc. So based on the item that is put to loss, you could have different classes of insurance that are there. First, where the problem or the loss or the risk could be to life, you have a branch called life insurance. And in life insurance, there are two risks that could be there. One, that you could die prematurely, or your life could go beyond your time when you are in employment. So for dealing with the premature death, you have aspects like your pure term policies, endowment policies, and whole life policies, etc. This could have variants like money back endowment insurance, etc. Or you would want to combine the insurance along with investment. So you would want to take up something called unit linked insurance policy, which is called a linked policy. The other problem that could be there is that you could be living too long. For dealing with those, you could have pension plans and annuities, which will be taking care of the longevity and provide you with sustenance so that you don't have to go through penury. This is as far as life insurance is concerned. Here, you are quantifying the benefit that is there. It's in a sense an agreed value contract. And in case the risk event happens, then you are supposed to be paid the amount. So there is not much of scope for arbitration. And most of the insurance contracts in relation to life do not have an express arbitration contract. There could be differences here and there, but by and large, it doesn't serve that purpose. Now coming to the other branch of general insurance is for protection of the risks that are there to property, business, reputation, and life, not involving the insurance that is covered by life insurance. That is, it could be accident benefit or something like that. So the three main branches of insurance that are in the general side are fire insurance, that is risks to business on account of fire or associated perils. The second insurance is marine insurance. It is risks to the vessels of transporting and also the goods that are transported. In this, you have marine hull and marine cargo. The third classification of insurance according to the Insurance Act is something called miscellaneous insurance, where anything which is not fire, marine, and life, that is all miscellaneous insurance. So the general terminology that is used is general insurance or non-life insurance. And in this, you could have motor insurance, where a vehicle, damage to vehicle or a third party could happen, and that is covered by the insurance. You could have agricultural insurance, where crops, cattle, etc. are covered. Then liability insurance, where you could be a professional like a doctor or an engineer or an advocate, and because of your negligence, if someone suffers and that loss is supposed to be compensated, you don't want to do it by yourself, but you want to assign it to an insurer. So this way, employees, trust, and other things, you could have fidelity insurance, etc. For big projects like roads, buildings, etc., you need to have insurance, engineering insurance, etc. The other subsidiary branch of general insurance, which has assumed a lot of importance, is health insurance, where the protection is against the health from the damage which is caused because of loss that is likely to be caused because of hospitalization, etc. Accident benefit and overseas travel is also covered under health insurance. The issues here are threefold. One is whether your loss is caused because of the peril that is insured. That is the first thing. And whether there is any intervening distance between the peril striking and the loss being caused. This is the important principle of insurance called proximate cause comes into being. This has to be tested, and this is a point which is there for dispute. The second thing is how much loss has been caused. Unless it is an agreed value policy, if the loss is not quantifiable, there could be a dispute in terms of quantification of loss. So from here, what insurance is supposed to do is it's not supposed to be a means of profiting, but it is supposed to be providing cover for the loss that is caused. And here you have a principle of indemnity. Then next thing that comes out of indemnity, suppose you are having more than one policies to cover a simple loss or risk that is supposed to be there. There is a principle of contribution which is supposed to be made by both the insurers in accordance with the premium that is subscribed to. This is principle of contribution which is flowing out of indemnity. Then the other principle is principle of subrogation, where if I am suffering a loss and insurer pays, and it is because of a negligence of a third party, insurer sits in my place and takes up the litigation. This is where it is the principle of indemnity operating, but the principle is called principle of subrogation, where the insurer sits in the policyholder's place and takes up a claim relating to this. So these are the various principles that are there, and these principles, unfortunately, are encapsulated only in the Marine Insurance Act. But in insurance law, you don't have these principles coming about. But these principles become important from the purpose of handling any litigation or arbitration relating to insurance. Now, the insurer is supposed to be providing you this cover for risk, and how does he provide? He provides it provided the person who is taking the policy is supposed to enter into a contract. So here, what are the elements of a valid agreement are there under the Contract Act? So a contract is nothing but an agreement enforceable by law. So the essentials of valid agreement, like parties competent to contract for a lawful consideration and a lawful object with free consent. These are the elements that are supposed to be there. All these elements are there, but uske aage there are few elements which are there in insurance. What are those elements? Parties competent to contract is there. That is, they must be majors. A minor can also be a beneficiary of an insurance contract. But the parties to a contract, the person who is taking insurance has to have an insurable interest. That is, he should be enjoying the benefit of having the property or the subject matter of insurance, and he should be suffering a loss or privilege in case there is any damage caused to that. So from that point of view, insurable interest is a very important element, additional element that contract of insurance requires. And if that is not there, the contract becomes a wagering. And imagine the next principle, the other requirement is lawful consideration, lawful object. The insurance policy, the person who is supposed to be offering insurance product is supposed to be a registered insurance. The product that is supposed to be offered has to be an approved product by Insurance Regulatory and Development Authority. Then IRDA approves products only which are lawful. The other aspect that is supposed to be there is free consent. Free consent can emerge only when there is full knowledge and there is full awareness about the terms of the contract insofar as the person who is taking insurance is concerned, and the terms, the condition of the person who is taking insurance for the insurer to know. This difference between the two is what is called as information asymmetry. So while a contract is a contract of good faith, the contract of insurance is a contract of utmost good faith, because there is a marked information asymmetry between the two parties. So from that point of view, disclosures become very important in a contract of insurance. And the terms and conditions that are there for an insurance product are also standardized, approved by IRDA, and only then put in the public domain. And one of the most important that is there in a contract of insurance of a general insurance nature is a contract relating to arbitration. And relating to arbitration, the clause relating to arbitration, there are certain variants. While some policies say that you are going to have an arbitration only when there is a liability which is agreed, but only in relation to quantum there is a dispute, we will have arbitration. That is one kind of a clause. Second, any aspect of difference between the insurer and the insured will be an aspect which can be arbitrated upon in the second kind of clause. And the third kind of clause is there will be a recourse which will be available, and there are various aspects to it. So the most important aspect of it is this, that the liability agreed, liability not agreed, any term of contract being subject to an insurance, and only being a subject matter of an insurance arbitration. These are the various aspects relating to insurance, different types of insurance, and depending upon different types of insurance, the different principles of insurance. And ultimately, the entire system of insurance contract is regularized through the provisions of IRDA Protection of Policyholders' Interest Regulations, which provides a safety mechanism for the policyholders in relation to all aspects of insurance, right from advertisement, proposal, terms and conditions of the contract, what should be in the policy, and what are the servicing of a policy, what should be done, and finally the claim stage, what is the process that is supposed to be followed. So anyone who is dealing with arbitration needs to have an insight into all these aspects. Thank you very much, sir.
Thank you, Dr. Mallikarjun. It was very lucid, and you have, in a short while, been able to communicate the intricacies of an insurance contract and how this is different from normal commercial contracts. And once the theory portion has been dealt with by you, I will now request Mr. Amandeep Singh, who was recruited as a legal specialist in national insurance and has had wide experience and is also now an advocate, to talk about his experience as far as arbitration is concerned in during his tenure as a insurance man in his company. Over to you, Mr. Amandeep.
Thank you, sir. Thank you very much. Am I audible to all?
Yes.
Yes.
Thank you, sir. First of all, I would sincerely extend my gratitude for involving me in this talk. And it's indeed a pleasure to talk to you all. And I have seen that a lot of participants have rich experience in surveys and assessment of losses, and also on the legal side. Friends, talking about arbitration in insurance, it is nothing new, but arbitration in insurance is a subject which is, in a way, we can say that it's an alternative dispute resolution mechanism. The importance of arbitration is can be described like in the words of Nani Palkiwala, who once addressing before the Chief Justice, he said that if I were appointed the dictator of the country, in the short period between my appointment and my assassination, I would definitely impose a law making international arbitration practice compulsory. See how the arbitration is differently dealt with in India and globally. What he said that arbitration would help to transform character towards less confrontation and more consensus, less litigation and more understanding, and above all, finality to the dispute. Friends, having worked in the insurance industry for about 32 years and having dealt with various legal matters, I would just share my experience and thoughts with you that in insurance, particularly in general insurance industry, what is the tendency is to avoid arbitration. Why avoid arbitration? Because there is a not trust level amongst the insured and the insurer. It's lack of trust. What is required in the basic fundamentals of insurance policy is that the arbitration can only be done when the loss is otherwise admissible, but the dispute is only quantum. Here, the insurance policy definitions, the policy condition itself restricts the arbitration. When we are restricting the arbitration quantum only, the very purpose of, arbitration being a very speedy trial, speedy system of giving resolution to the grievances of the customer defeats. But again, the Supreme Court has held in one of the judgment of Oriental Insurance versus NPCL that you need to have the strict implementation of the policy condition. So they have referred both the clauses of arbitration, part 2 and part 3, in the arbitration clause, which is in the insurance policy, saying that it is harmonious and you can't raise a dispute if the liability is not otherwise admitted. So the tendency is to pick any condition in the policy and say no to the arbitration, because the insurer feels that if I go for arbitration, it is likely to be passed against me. Now, while deciding most of the claims which we were dealing in insurance industry, sometimes it leads to the borderline cases. You can decide either way. You can pay the claim or you can repudiate the claim. Now, most of the issues which have been referred in the disputes, if we go to the root cause of the problem, there is a resolution, because insurers deals with the reports based on the loss and assessment made by the surveyors. Now, surveyor, most of my participants here in the webinar are surveyors having a rich experience in the field. But when giving the survey report to the insurer, they escape with the remark that without prejudice, the insurer should decide admissibility. But at the same time, ignoring the fact that the surveyor's responsibility under the IRDA regulation is that he is to investigate the loss, he is to approve the loss, he is to make recommendations for settlement of a claim, or he is to make recommendations for repudiation of the claim. So there is little scope left with the insurance company to go. And there are various instances I can share with you that while deciding a claim of damage to the building, we are saying that if a building is owned by a sole proprietor of the firm, but the plot of land on which the building was constructed was not in his name or in the name of his family members, so you'll say that he is having no insurable interest. Particularly when a family deed existed, there is, accounting of all the expenditure incurred on construction of the building, and those have been accounted for in the balance sheet of the firm, and the firm is owned by a sole proprietor. We are saying that no, loss is not payable because the insured is not having an insurable interest, which leads to otherwise the claim is very well admissible. But raising a dispute on any policy condition or saying that it was an exaggerated claim filed by the insured, so exaggerated claim amounts to a fraud. Now you are repudiating the liability, saying that it was an exaggerated claim. Another viewpoint can be taken that in a fire policy, there is a condition that if any one bill is found fraudulent, the entire claim shall be stand forfeited. Such a condition doesn't exist in the motor policy. But then what the insurers are doing, they are repudiating their liability. And then there is a need. Once you are repudiating a liability, you are treating it as a prestige issue that the court should decide and let the court should pay. We are not going to review the claim. No doubt about it that the IRD has given various regulations. The policy holders protection interest regulation is there. There are regulations that IRD has given that the claim should not be repudiated on the delayed intimation of the claims. But still, the insurers tends to avoid the liability. They are not entering into. They are taking it as a escape route to repudiate the liability instead of admitting the liability, so that the arbitration clause doesn't come into future. And in most of the health insurance policy, particularly when the health insurance scheme sponsored by the state government or the central government, there are provision of a sole arbitrator. Now, the sole arbitrator, the Secretary Health would be the sole arbitrator. They will be deciding the case in their own favor. They will not be listening to the insurer. So, very fundamentals on which the law stands, those are not religiously being followed by either the insurers or the insured persons. That is how the arbitration in insurance is not being, advocated by many of the insurance companies. And the disputes are simultaneously dispute resolution mechanism is that consumer forums are there. Earlier, no doubt about it that the amendments have been made to the Arbitration and Conciliation Act. Earlier, there was a provision that any award of the arbitrator was required to make a rule of court. Now, after the amendment of the Act, it doesn't require. Still, we are fighting. Once the award is there, either we can challenge it that it is not properly stamped, and then for the registration purpose, we are sending it to that it should be properly stamped, and we are challenging the award. Either the award is challenged by the insurance company or it is challenged by the insured person. Because that is why the word conciliation has more relevance under the provisions of Arbitration and Conciliation Act. There is a provision for mediation. There is a provision for fast-track applications to be moved. And under the fast-track applications, only the sole arbitrator is required to be appointed. And in the policy condition of the insurance company also, there is a provision that the sole arbitrator is to be appointed. But if it is not agreeable for sole arbitrator, each of the party can appoint the arbitrator, and then there is a provision to appoint the umpire if it is to be decided by both the arbitrators. Not deciding by the both arbitrators, the matter will go to the court for appointment of the presiding arbitrator. So, my submission is that we should go to the root of the problem and say that the insurance policy conditions needs to be amended. Arbitration clause needs to be amended. Arbitration should not be restricted only to the quantum area. Arbitration should be for all the matters which Pasha ji and Shri Mallikarjun ji has already referred. There are various things that the insurance companies deny the liability either on insurable interest or on the fraud being exercised on the insurance company by filing an exaggerated claim or like that. So it's a human tendency. There are various judgments of English law which says that it is a human tendency to file an exaggerated claim so that the person should get an appropriate amount for which he is required to be indemnified. So the need of the hour is to make an amendment in the policy condition. We should go to the IRDA, say that policy condition for arbitration clause should be there for inclusive of all the denial of liability, that the arbitration jurisdiction is rested on that. Thank you very much.
Thank you, Mr. Amandeep Singh. It was very interesting, your experiences which you have had and how these things have... Before I proceed, can I request Mr. Harendra Prasad Singh to... it comes as Harendra Prasad Singh is presenting. Can he go back? Stop presenting? Hello, am I audible?
Yes, sir.
Yeah. I request Mr. Harendra Prasad Singh to stop presenting because that's taking up the screen space. Now, I come to a person. Thank you, Mr. Harendra Prasad Singh. I now come to a person who has had wide experience both in the public sector as well as in the private sector at senior levels, handling technical and also arbitration and other cases. And his experiences would be of great use to all of us. I request Mr. K.K. Mishra to share his thoughts with us.
Thank you, Srinivasan, Vijay Srinivasan. I appreciate the time spent by co-panelists. And Mr. Ramandeep did say strongly about amending the condition. I agree basically with him, but before I start, I would like to, because there are students, there are lawyers, there are surveyors. So I'll take 2 minutes on basic alternate dispute resolution. Because arbitration is part of ADR. And I personally feel, with my experience of 40 years plus, it's an amicable dispute resolution. The very first thing, 80% of the business in India today is auto and health. How many customers know that arbitration clause is there first? And what's the grievance process? IRDA is very specific. There is a grievance process which IRDA also moderates and looks and asks question. Almost 90% of the grievances are attended to. If he is not satisfied, he can always go to ombudsman, which almost about 20 or 20 or 30, I'm not sure about the number. All each states have a ombudsman insurance ombudsman, where an individual can go, and there is a valuation increase also there. Even private companies can go there. They have an option to agree or not agree with the ombudsman's decision. But insurance company, if the ombudsman has approved the contention of the insured, insurance company will have to admit that claim. I have my personal friends in ombudsman, and both in life and general, almost 90% claims go in favor of insured. So that's the second point. The lawyers must look at it. And the surveyors also should suggest, if they have recommended a claim, they should recommend individuals and private companies up to a certain limit to go to ombudsman first. And they can always help as a what should I say, facilitator for arbitration with the insurance company. And why I'm saying arbitration is the first stage is mediation. Mediation nobody is doing in India, but ombudsman can mediate. So that's the first thing. Third thing comes consumer forum. Consumer forum, almost 600 consumer forums are all over India. And the state forums are almost 30 plus. And the NCRDC, that central forum is always there. And anybody can go to them with any condition of the policy. Again, that's a mediation. That's the courts upheld almost all decisions of the consumer forum at the national level. Because after national level, the only thing is left to Supreme Court. So what I'm requesting all insured people, as well as surveyors, as well as lawyers and practicing insurance company people, they should guide people about these alternate amicable dispute resolution. This is one thing why when I moved from even Tata in United India, my CMD was very supportive. I did negotiate claims. I did pay claims at that time. And CBI never came after me because my notes were always clear. When I moved to Tata AIG with the experience of AIG, was staying with AIG for almost 8 months, with the experience of AIG and particularly in developing country, first thing I started, third-party claim must be negotiated. At one stage, 70% of third-party claims were negotiated by Tata AIG. And because lawyers know, the Supreme Court has laid down specific specific standards for third-party claims. I'll not take time on that. I'll come back to finally on arbitration. India has a difficult problem. 80% of the claim come under, or by number, almost 95% claims under personal line. So they have to go to either what you call consumer forum or, just a minute, Amandeep, you are, yeah, I'm coming back on the screen. Okay. So coming back to arbitration, the 95% of, I understand that somebody has asked the question also, yes, the condition has to be changed. But before the condition is changed, you can always go to mediate, mediate, go to consumer forum, go to courts for this. I'm not recommending that, but that's a process available. Coming back to 95, I would like to say people of insurance, now the high rise claims in arbitration, almost there are 100 plus arbitration cases in commercial line, particularly in D&O, particularly in EPI, particularly in CGL, particularly in what you call cyber security. And if nobody has seen that, then you can write to me or you can write to Wahab. I'll share the condition on dispute by these companies done. Another thing which the first big arbitration in India happened, almost 1,000 crore plus, was with a ALOP, advanced loss of profit, where there was a claim control clause. I was lucky to be working with United India. It went to all steps. Finally, it was settled in 2010-11. I was last time contacted by company for some clarification in 2009 or 10. Finally, QC of Queen's Council of London came to India. They spent almost 25 days to settle that claim. Why I'm saying that, this is not that arbitration, big value claims are not there in arbitration. So, dear surveyors, dear lawyers, I agree entirely with Mr. Pasha that nobody knows about mediation. Most of the people don't know about how to go about arbitration in the commercial line, which is a high value claims. So they have to look into that area. So that's my personal request. Coming back to the issue, one must look at protection of policyholder interest, and they should guide their customers on that. I will come back to the point of arbitration, how it is successful. With my experience again, and Vijay knows about it, Wahab knows about it. See, the mediation or arbitration has different steps. The first thing, you have to identify the issues which you want to fight, the customers as well as the insurance company. Somebody has to be responsible for that, and the senior management, I'm talking about the directors and the managing director or the CEO, he should be interested in arbitration proceedings. I'll just give an example from an article from the HBR, Harvard Business Review. There was an article about what made arbitration successful for good companies. They cited the example of Toyota in Japan. They cited the example of AT&T in US, and also Motorola. All these three companies have a manual on. Sorry, there was a question, so I just wanted to read that. Anyway, I only want to say that all three companies had a manual for a middle management, which are the points they should go for arbitration, or they should not negotiate, they should mediate, and they should agree to the customers. So that's the process the developed country has started and doing it. Same thing happens with London. And Mr. Pasha knows it, that in Canada and US, the court first question he asks, did you go for mediation? Did you go for most of the commercial cases? One good development has come in India. There are commercial courts in Act in 2015. They have earmarked at the district level, at the state level, at the central level. So that's a good idea. Finally, on the arbitration, 2000 Mr. Tripathi, you can ask me questions separately because I don't want to get disturbed right now. Okay. So, coming back to 2019 Arbitration Act, a lot of good things have been done in 2019. There are a lot of data bank on the arbitrators, but this act says that Arbitration Council of India by Government of India, and they will empanel arbitrators. They have given qualification also for the arbitrators. The only problem is after 19 they were there. After 2019, the government have a different problem because right now it's happening. So many things have not moved on that. So what I'm trying to convey, there has been a lot of changes in arbitration law, and all lawyers and must get ready with the changes in the arbitration law. Insurance company, I agree with Amandeep. The condition has to be changed. IRT has to look into it, and at least they should ensure a condition that mediation is must if there is any difference. So that's what I am trying to say. Already it's 12:19. I started at almost at 12:07, the 12 minutes. So I don't want to. I have many things to talk about it. The last thing I wanted to say, I wouldn't discuss many cases which I wanted to discuss with you people, but which is live in India, or which was decided in India. Anyway, going back to the only thing, if people are not understanding arbitration today, class action is behind us. The lawyers must know the Company Act has already introduced Act has introduced class action, and class action, any 100 shares can do it. So be careful about it and look at the arbitration and look at the arbitration by 100 people together against any company, particularly at this stage. HDFC bank has been, there is a case in US. They have charged a class action against the shareholders of. What I'm trying to say that law is evolving, and the lawyers and young people must abreast themselves. And I thank Iram and ASEAN and Sadri for conducting this program. And I request that people who are serious, they should write to Wahab, and they can have a different aspects of arbitration for teaching you people. Thank you very much. Vijay, if any question is specific, come back to me. Thank you.
Thank you, Mr. Mishra. It was very illuminating, your experiences, personal and otherwise. And we have some questions also, and final comments also from each one of the speakers. My first question to Mr. Pasha. There is a question from Mr. Birpal Singh, who has raised a very interesting issue, that can the Supreme Court and High Court not issue instructions to the lower courts that whenever a dispute comes up, whether they have tried out arbitration first. Can the bar councils play a role in this? Mr. Pasha.
Sir, it's a very interesting question. And I'm sure the Supreme Court can lay down certain rules and regulations for the lower judiciary to resort to mediation, not strictly arbitration, but mediation, and resort the small issues that are there in every case that is coming up before the judiciary. I'm sure that can be done.
Vijay, can I say one line?
Yes,
Vijay?
please.
The Supreme Court has awarded in Narve Ram case, Oriental versus Narve Ram. They said they have upheld the arbitration clause. And same thing happened with the United India. They have not changed the law so far. But I only look forward that new judges may look into it. And I wish all success to Mr. Pasha to take it up to Supreme Court to direct lower courts. As on date, 2000, the Narve Ram case as well as Hyundai case is very clear. And commercial courts are always there at this stage. Thank you.
Thank you. That's maybe Mr. Pasha can actively think about it and we can all join in.
Thank you, sir.
Mr. Malik, your comments as well as a couple of questions to you. Mr. Tripathi has asked a question that only quantum disputes can be referred as per arbitration clause. Why not all disputes? And Mr. Pratik also has raised a question. Why is arbitration frequently not used in general insurance?
See, the wording of the clause is something which is restrictive, but the fact that all these policies tend to go to Insurance Regulatory and Development Authority before they are approved should give good reason to take it up primarily with IRDA to incorporate the essence of arbitration into resolution of disputes. I will just give you a small example where IRDA institutionally has indicated that the arbitration should be only on quantum disputes and not on any other disputes of any other kind. In the health insurance policy that they have come out with, which is a standardized policy called Arogya Sanjeevani, they have indicated that it should only be in relation to the quantum and not anything else. So this indicates the general perception or the feeling that is there in IRDA while approving conditions is that they were only interested in allowing arbitration for quantum and nothing else. But this being the case, there are other policies like engineering risk policies and some shopkeepers policies, etc., where they have specifically incorporated a clause that any issue can be arbitrated upon. The intention probably could be that we are talking about quantum only disputes taken for arbitration, because in health and others being retail policy now, they can approach the ombudsman who will do that mediation and allow resolution. But in larger disputes, if you have a restrictive clause, it is going to put enormous strain on the system. As far as arbitration being mandatory before any suit is issued, some of the arbitration clauses make it very clear that no suit can be entertained in respect of this contract unless arbitration award is indicated. So this is a clause which is very important, which is forming a part of some, but it is not forming a part of others. So while I have been in IRDA and I have seen them, they are very meticulous in coming out with a standardized terms and conditions for life policies, and they have done the same thing in respect of health policies. They have not been in a position to evolve these kind of standardized clauses for other policies. So it's high time that we take up the matter so that every aspect, it doesn't take much of an effort to refer it to the arbitration system to be kicking in for dealing with disputes. The only thing is make the contract facilitate this resolution mechanism. That is my take as far as this is concerned.
Thank you, Mr. Mallikarjun. One interesting question from one Mr. Sanjeev Chopra wanting to know how many insurance cases are pending in the courts and how much will be coming up. Well, now, Mr. Chopra, I don't think offhand we'll be able to give you the number of insurance cases. There are roughly about 44, 45 lakhs of cases pending in the courts as of now. But as far as insurance cases with respect to insurance cases in courts, I can confidently tell that the bulk of the insurance cases would pertain to motor accidents, third-party cases as we call. The other branches of insurances, in terms of numbers, may not contribute much, though in terms of volume, they will be substantial. In terms of quantum, they'll be substantial value. But in terms of numbers, the number of insurance cases, the numbers would be large from point of view of motor third-party cases, maybe a few, close to 10 or 15 lakhs or whatever. And there are periodical methods adopted by the courts, including lok adalats. So, in fact, Supreme Court has almost institutionalized this concept of Mahalok adalats, where every year they have started conducting Mahalok adalats under the aegis of the Supreme Court, and high courts also do it. And there are some fast-track courts as far as the permanent fast-track courts for lok adalats. Various methods have been adopted. And now the law also is being changed to see that the number of cases don't come in to the courts at all. So these are certain steps being taken. I hope that partially answers your question. About the total number of insurance cases, I don't think we'll be able to offhand tell you. Now, Mr. Amandeep, there is a question which, if you can handle. People are shying away from arbitration because of lack of structure in respect to time frame, remuneration, and place. There is another question by Mr. Tripathi, who has also made a comment that surveyors are appointed as arbitrators, and they are often influenced by the insurers to, handle the cases in a particular way. What would be your thoughts on this subject? Mr. Amandi, you'll have to switch on the mic.
Yes. Am I audible, sir?
Now.
Hello.
You're audible now.
Audible now. I am in agreement with Mr. Tripathi. He is having right observations on the issue. You see, when we are appointing a surveyor as an arbitrator, naturally, the intention of the insurer is that he knows the factual position, he knows the terms and conditions of the policy, and he will go and he will, pay what he pay. Now, unfortunately, what is happening, I am telling you the practical approach of the things in the industry, not talking about national insurance or talking about any other insurance company. If an arbitrator decides against the insurance company, he will not be allocated another case to. I mean, if he is on the panel of arbitrator, if he is deciding the case against the insurance company, he is not being allocated another case. This is, unfortunate part that once the arbitrator is deciding the case impartially and based on the principles of natural justice, based on the documentary evidence available then there should not be any hesitation in, ignoring the fact. And in fact, this arbitration process should be institutionalized. I can share with you my experience when I was law officer, and I used to appear in the year of late 80s. There is a system in the Himachal High Court. Justice Desai was the Chief Justice at that time. He introduced a system of conciliation in the tribunals for deciding motor third-party cases. What was that? You are supposed to file the written statement after the petition is filed by the claimant for claiming compensation. So once the written statement is filed, before framing the issues, there was a mandatory meeting for conciliation. The issues will not be framed by the court unless the matter is taken up for conciliation. If the parties, both the claimant and the insurance company, agrees for a settlement, we used to settle those cases then and there, because till the time the written statement was required to be filed, we do investigate the matter, collect the all documents, and then see that there is a prima facie liability against the insurance company. And now the dispute is only on quantum. We can discuss the quantum in the court and then offer the amount for compensation. And that was in a just 45 days, 60 days time, the claimants were getting compensation. Now see the reality in other claims. I am of the view that even the motor own damage claims can be settled mutually. Mutually. It should not be, even third party cases can be settled like OD claims, and OD claims can, all those disputes can be settled mutually. There are guidelines by the IRDA. Now, various grievance system has been institutionalized. There is a procedure that you raise a grievance and then it will be dealt with by the appropriate authority. And still, if the party is not satisfied, it can be relooked into by the regional authority. So, in a way, both the insurance company and the insured are in an advantageous position if the cases are mutually settled, and it should not be dragged to the courts. There is increase in the business and there is volume of business. With the volume of business, the litigation is also increasing. And you yourself has said that courts are burdened with the cases. Now, the courts are dealing cases for 6 months' time. For one hearing is postponed for another hearing for 6 months. Whereas, under the Consumer Law, Consumer Protection Act, the statutory period of deciding a complaint is 3 months. And the second part is, sir was right in saying that the issues can be raised to the ombudsman. But fiction part is there. 20 lakh was the only amount which is to be decided by the ombudsman. In the consumer forum, now recently there is an amendment under the Consumer Protection Act. And now the pecuniary has been increased to 1 crore for the district forum and 10 crore to this state commission. And beyond 10 crores, the jurisdiction of original jurisdiction lies with the National Commission. So what is important is to decide the cases then and there. And the insurers should feel that if the claim is otherwise admissible, payable within the 4 corners of the policy, it should be paid. It should be paid, you see, graciously. And not that you are finding one condition or the other policy condition to repudiate the liability or deny the liability.
Thank you for your detailed reply. I hope Mr. Shastri and Mr. Tripathi, your queries are answered. Yes, Mr. Mallikarjun, you wanted to say?
I have a small information to share. So I will share my screen for a moment. So I would like, because this is the data relating to case someone was asking now. So I remember when I was there in IRDA, we had asked for a statement to be given. So a consolidation of it is there in the IRDA website. So this is the number. I don't know whether you are able to see the screen. My screen is visible, sir?
No, I cannot see it.
So the total number, let me just give you an idea. The total number of cases that are there in life at the consumer forum, there are 13,784, state level 6,320 and national level 552. In non-life, 56,000 are with the consumer forum district level, 21,000 state level, 3,617 at national level. In high courts, there are 2,098 cases in life and 1,800 cases in non-life. In civil court, 7,900 life and 1,768 non-life. Then Supreme Court 125 life and 1201. This is a compilation of information that is presented in the IRDA's Consumer Affairs Booklet Annual. So there is all the insurance report, and that figure has been compiled and presented in the report by IRDA. You will find it in the Consumer Affairs Booklet. Thank you.
Thank you.
Mr. Vijay, I'll just butt in what Dr. Mallikarjun said. All this data we should take with a pinch of salt. I mean, I was in head office Oriental Insurance looking after consumer cases. And unfortunately, I mean, I can talk about the public sector, not about the private sector. And the data, especially regarding consumer cases, are not exactly, I mean, I wouldn't say they are very accurate. I mean, there's still public sector insurance companies are not giving that kind of importance to, especially consumer cases. That's all I want to say. Thank you.
And this only underscores what I had said earlier, that it perhaps doesn't take into account third-party cases in the tribunals. So that is a huge chunk. And the numbers which have been said run into maybe all total up to 1 lakh or so. Third-party cases alone would be many times this.
6.2. MACT cases are 6.2 lakhs, sir.
Yes.
And so state level, there are 1.6 lakhs.
Yeah. So that is what it is. And the other cases will be only a portion of the total. So third-party cases constitute a lot. So we have got a complete picture of the statistics. Now I'll request Mr. Mishra to answer the question of Ima Hussain about difference between arbitration and settlement.
What's the question?
Difference between arbitration and settlement.
Say, arbitration also finally gives an award, which is a settlement. But settlement is normally with the claims or any demand from the consumer. So that's the settlement at the negotiation level. In arbitration, it's more of an award at the final stage after hearing both the parties. So they give an award which can be in favor of the litigant or the insurance company. So that's the only explanation I can give it. If you want a definition, exact definition, I'll share with him separately. But this is for webinar. This is the difference between settlement and award.
There is one more question to you, Mr. Mishra, from Mr. Kannan. It says insurance companies very often reject for stating, using the term technical reasons. So for small cases where the quantum is not much, it's very expensive going to a court. So his question is, can there not be an independent arbitrator who can decide whether the refusal of the surveyor or the insurer is correct or not?
So very simple. He should go to ombudsman. If it's an individual claim, he should go for an ombudsman. If he has a company or a big company, he will not go for a small claim. But I agree. That's what I said. Mediation is the must for insurance company. Only thing I would like to say, people talked about the data and Wahab also made a comment. Yes, data is data. Say, any data can be interpreted the way you want to interpret. But should we not understand? See, the problem with the insurance industry, we never talk about the positive of the insurance industry. 97 to 98% of the OD claim and third-party claim and health claim are being settled by insurance company. It is humongous number. So we don't talk about that. We talk about which are pending. It's a pending. The number of policies are being issued in India today. So, and all data is available. And whatever data you take from IRDA, if you think that the pending losses are high, they should also look at the data on the policies issued by insurance company, both in life and general. There with that, the percentage, so last time I did in 2009, the percentage came to dispute claims or court claims came down to 3% of total policies issued, less than 3, sorry, not 3%, 0.9% of the total policies issued that year. That's the fact. You can, anybody, any research student can look at the numbers policy issued and claims. That means how many consumers, how many court cases. That's all I can say. Please don't berate insurance industry. Insurance industry also has done a good job. As an insurer, if you don't take pride in insurance working, say I said somebody talked about third-party claims and all that. 70% negotiated and paid. That's what I'm trying to say. Thank you.
Yeah, thank you, Mr.
I'm hurt with always saying that insurance companies are bad. Both public sector and private sector, they do their best. We all know that we try to pay the claim. Most of us, I will not comment with everybody, but most of us want to pay the claim.
Yes, in fact, a claim settlement ratio, which is an indicator of claim settlements, is generally of a very high order. More than 90-95% of the claims are settled. Only the balance remain, and there could be some kind of and when you talk in terms of the number of claims which run into lakhs of claims, I think it's not very big. Of course, that is where the issues happen, where there are claims are rejected, and there perhaps more concentration is required how to smoothen out the case. But the industry does settle a huge number of claims on a regular basis, and people are benefited out of it. And on the same line, Mr. Raghunathan has asked that there is a tendency because of audit and vigilance for people to avoid settlement of claims and pass it on to the courts or to the consumer forum. Or so I think Mr. Mishra wants to talk about it. Please go ahead.
I retired from United India after 20 years. I did face CBI 3 times, as there were some cases, but head office. All my notes, I was always descriptive note when I passed a claim. CBI never charge sheeted me. In fact, at one stage, I became their consultant. So I agree that public sector has a problem, has a problem of vested interest, because all the cases which were sent to CBI, you know that who sent the files. So that is okay. That's part of life. But if you're taking a decision with conscience, not taking money, and you're writing my personal experience, okay, everybody has bad experience, a good experience, I'm not commenting about that. But you have to know your subject and do. I entirely agree, public sector had a big problem with vigilance, audit, and bosses. So that's your luck. That's all I can say.
Yeah, I would also like to ditto what Mr. Mishra says. And having spent almost 4 decades in this industry and having held various positions, involving various financial aspects, I can tell from experience and experience of a whole lot of people that people do take decisions, and that's how claims are settled. And that's how the industry keeps going on. Yes, there is a scare at times when people, try to pass on the buck. But then perhaps what is required is to find out more and more ways and means of the processes being streamlined in such a way that everything becomes transparent and people don't have to be bothered or scared of any of these agencies. Decisions are taken every day, hundreds, thousands, lakhs, millions of decisions are taken by everybody in the industry. Mr. Amandeep wants to come in. Yeah. Your mic is not on.
I worked in vigilance for 4 years in head office. You see, it's all. I would not say that the people are scared of vigilance. You see, it is vigilance is another branch of risk management, I would say. In the industry, you can only be touched if you are not justified in giving your reasons. When you are preparing a self-speaking note, one judge is differing with other judge. It's your interpretation, your thinking, your wisdom. When you are taking a decision on any policy condition, I mean, High Court is saying that Part 2 and Part 3 of the arbitration clause are not in harmony. Supreme Court is saying it is in harmony. But that doesn't mean that on any claim, if you are deciding, vigilant people will come and catch you. But yes, one must take a vigilant decision. There should be a self-speaking note saying the reasons for your repudiating the liability or reasons for your approving the claim.
Thank you, Mr. Amandeep. I think all the insurers...
liability than to pay a claim.
Yeah.
I mean, experience is it's very difficult to repudiate a claim, but it is very easy to pay a claim.
Yeah. Thank you, Mr. Amandeep. I think all the insurers have risen up at this statement. But anyway, I mean, we need to address the issue of the claims which are not happening, and we need to develop systems and processes to see that these things don't happen. And people need to be educated about it. Mr. Pasha, once more.
Vijay, well, I just want to say one point here. I mean, there are quite a few, talks on CBI and vigilance and all that. I have been going to CBI Academy, Ghaziabad, since 2016 and trying to tell the CBI officers of all cadres up to DGP cadre that what insurance is all about and what is frauds. And I tell them that insurance companies, they are fraud, but more frauds are outside the insurance companies. Now, looking at the interest of people, and I find quite a few people, are talking about this aspect of fraud also, and CBI also. We are planning to have a webinar on this fraud insurance, and along with the CBI people. Maybe we will have one or two speakers from the CBI side, maybe retired, maybe serving. So I wanted to say that. So there are a lot of aspects which has arisen because of arbitration, and we will be touching on quite a few of those aspects in future webinars. Thank you.
Thank you. Mr. Pasha, one small question to you. Deshpande has raised a question that there is a need for panels of arbitrators by insurers.
Yes.
As a arbitrator yourself and having vast experience, what are your thoughts on this? Do we need to structure?
No, there should be a panel. There should be a panel of arbitrators, sir. It is important because the knowledge of insurance today is lacking in a lot of judges also. When we put up our cases also, the law of insurance is a specialized field. And those people who know the law need to be there as a panel. Yes, I agree with it.
Thank you. Mr. Mishra, one small question to you from Mr. Kashyap, saying that courts appoint legal personnel and not insurers as arbitrators. What are your thoughts on this?
What Master Pasha said, I agree. But see, 2019 Act is very clearly said there will be Arbitration Council of India by Government of India, which judge will head it. And there is a very clear qualification given in there. Anybody who is having a law degree with 10 years experience, anybody having engineering degree, anybody can read the Gazette. So it's very clearly available. Problem is because of Corona, they could not appoint the Arbitration Council of India chief. It will take time, but I entirely agree. And okay, I only want to submit, there are insurer conciliators, insurer arbitrators. There has been cases where people have been appointed from insurance industry. I know at least 10 or 12 people who have been, say, few number. Most of the companies go for judges. And my experience with the judges, with all due regard to them, they know the law point. Most of them don't know. And finally, my bad experience has been that the Supreme Court judge finally said, Mishra ji, क्यों नहीं settle कर लेते हो? क्यों award मांगते हो? आपस में settle कर लो. So what I'm trying to say that Chief Justice, retired Chief Justice, as a CEO, told me that why don't you go for a negotiation and close the claim? Because if I'm going to give an award, it will be much harsher for you without understanding the issue. Finally, we talked to the customer and we decided to some amount which customer was not willing, but finally we did. So my experience with the judges, with all due regard, they know the law point very clearly. But their bias is most of the time, with all due respect, in public say there are some great judges. I have come across some great judges who knows insurance much better than me. So there are all type of judges there. But their basic idea is the mediation is the best way of settling a claim. That only thing I'll say from London market, the QCs, Queen's Councils, and US market, the mediators, they are dyed-wool people of the arbitration. So that's what I was requesting all lawyers, surveyors. And I personally, I have seen a surveyor, arbitrator who was very honest, very pragmatic. Of course, he was from the Western world. So my personal view is it goes with the integrity of the person, and there should be a panel, and insurance people must be taken care. And I request ASEAN also to look towards that, and Sadre also to look about that, and they should propagate or they should make a list of insurance arbitrators. So this is the time we should do it. And finally, when the Arbitration Council of India by Government of India is done, we should go to them. No issue.
Thank you, Mr. Mishra. Now, a question from Renuka Aluwalia asking whether arbitrator can fight for and against the company simultaneously. I would like to say that arbitrator is the form of a judge. So they don't fight on behalf of any party, though there is a provision for arbitrators to be appointed by each party. But where it is appointed by each party, the numbers have to be odd number. That is, each party will appoint a certain number of arbitrators, say 1 or 2 each. And then there will be one person who will be the umpire, who will decide, who will also be there. So that any award which comes will have it will be by a majority. So I hope that takes care of the clarification. And 2 small questions before we...
Vijay, can we limit it to one question because we have passed...
Yeah, these are 2... Yeah, we'll do that. Mr. Mallikarjun, questions to you. We are running short of time, so very quickly. One is from Mr. Mahendran, who says that, who's asked who initiates the arbitration. And second from Mr. Shivraj, whether there could be pre-agreed arbitrators in an insurance contract.
As far as who initiates the arbitration, the one who has the dispute will be the person who will be initiating the arbitration. So if it is that is the first part of it. As far as pre-initiated arbitration is concerned, where there is a standard format of contract where you are entering into, there is no scope for it. But in case of specific general insurance policies where you are adding conditions, specifying things, you could have a situation where you can have a contract with pre-decided arbitrators from either side who will be arbitrating on the dispute. So because it's not a standard format contract that you are entering into, you can name the arbitrators in case of a dispute.
Thank you. I think that clarifies the position. And I think that answers all the questions also. We've handled the questions. And it's been very informative. I have learned a lot from the session, from all these, from my eminent panelists, and also from the questions which have been put, very insightful questions by the participants. To sum it up, what I would like to say, I would just like to wind it up with a small quote from Mahatma Gandhi on arbitration. He has said, "Differences we shall always have, but we must settle them all, whether religious or other, by arbitration." So, since times immemorial, arbitration has been the favored path, the first step, and people look forward to it as being the final step also. And other forms should come up only much later if arbitration does not succeed. So I thank all my panelists for their excellent presentations. I thank the participants for their involvement. Now over to you, Mr. Wahab.
Huh?
Over to you.
Yeah. Thank you. Just one second. I'll just take. Thank you, Vijay. Thank you very much. I also like to thank all the speakers and especially the participants who have put so many questions and some very tricky questions at times. And that shows that the level of participation was very high in this webinar. And we feel really honored that a lot of many people have come to participate, and quite a few people could not get, could not be admitted because Google, I was hoping they will allow 250, but they have restricted to 100 only. I've just posted the link for the feedback, and I hope that you can all see on the chat. This link on the chat I have put for the feedback. So apart from your questions and your comments, if you can fill up this feedback, it will give us a better idea how this webinar went. And the next webinar, which we planned again for arbitration, how we should structure it. So my request to all of you is take just 5 minutes. You can fill it up. You're jotting down so many points on the chat. And I'm very thankful to Dr. Malika Arjun pinpointing the legal aspects. And of course, I'd like to thank all the participants for participating in such a manner that has really given us a lot of heart. And we feel that this is an area which should be taken up vigorously by the insurance companies, if not the general clients. And arbitration should become the way claims are being settled by the insurance companies, whether public sector or private. And of course, I'd like to thank my technical team who are behind the scene, who has helped us organize this program. So I'll again request kindly fill up the feedback form. And I'd like to say goodbye to all and hoping to meet you all again in the next webinar. And incidentally, we did not mention in the earlier, this program was being shared live on YouTube. We have a YouTube channel. We have just started with the same name, ASEAN Institute of Insurance Risk Management. Maybe if you search it, you will find it. And on our Facebook also, there was a live feed, both the channels. Thank you once again.